I think we'll kick it off. So, welcome everybody to East State Academy. And today we're talking about the fundamental issue of executors and picking them and compensating them. And I'm here with Ian Hull. And why don't we kick it off? Let's just talk about our agenda for today's session. We're going to talk about the role of the executor, factors to consider when you're selecting them, how many to appoint, and then decision-making rules, and then some compensation options and issues. So that's what we're going to try to cover in half an hour. So maybe I'll just ask you, Ian, if you had anything to kick off on the whole issue of executors before we get into some of the nitty-gritty.
Well, I just my initial comment, and we'll play this out for sure today, is this is one of those issues when you're taking will instructions. I definitely like to project out where this will land and how it will land, because of course a big part, and too big quite frankly, part of my practice on the contentious side is dealing with executors, and in some respects dealing with executors who have been sort of not thoughtfully considered in their appointment. So I think that's sort of a general theme that we can do our best to try to avoid, and that's where a lot of these discussions can take us.
Yeah, and just to echo that, my estimate is that the selection of executors leads to more disputes, maybe not litigation, full-blown litigation, but more disputes than probably anything else. And so let's look at sort of what the role is so that people can, and this is important for the client to understand, because they're the ones who are going to ultimately pick the person who has to take this on. So the first point that I would want to make is that, look, their job starts immediately on death. And I'm just going to run through these are some of the issues that they're going to have discretion on, because those are the important issues. Like, the person you're picking is going to have discretion about funeral and burial. They're going to have discretion about, their job is to collect all the assets, but that entails selling assets, maybe holding on to assets, decisions about that. That's going to be a discretionary decision. Paying debts and liabilities, that's probably not going to be a lot of discretion unless there's a fight about whether one of the beneficiaries owes money or a hodgepodge clause or something like that. Dealing with financial and tax filings, government filings. And then their job ends when they distribute the assets, the estate, in accordance with the terms of the will. So that's what I make sort of clear to the client as far as the executor's role. Now, they may also be a trustee of a trust that's established in the will, but technically their role ends when they take the share that was to go to that trust and deliver. Now they take on the role of trustee of that testamentary trust. So those are distinct roles, and the executor's role basically ends when the estate is distributed, whether it's to a person absolutely or in trust. Ian, any
yeah, well, it's a, it comes up a lot, this time when you say you're executor and trustee, and when does it kick in? And when you say distributed according to the terms of the will, sometimes that is a bit of a muddy moment in time. And so it has some impact, of course, on the beneficiaries, because they want to know when they're going to get what and on what basis. So when an asset gets converted into a trust as in accordance with the terms of a will or something like that, that at that moment in time, that executor is now a trustee of that trust, and with it comes with different obligations and different considerations. So although we tend to use the words interchangeably, when things can get contentious there, it's worth rolling our sleeves up and determining what role they're playing and on what basis.
Right. So what are some of, and I tried to put together some of the key attributes or issues or factors when deciding which person or persons to pick as an executor. So I'm sure I've missed some, and we would welcome any additional ones that people have, but I put trust at the top. That's kind of a key one. And obviously they're often referred to as trustees. So they're going to have to be somebody that the client feels confident with and trustworthy, and who's trustworthy in the eyes of that client. Maybe we'll
And
jump to.
sometimes that trust gets misplaced too, and it's based on familiar relationships and not thoughtfully considered because of the uh, impact of that choice. So trust is something, we kind of come in at the drafting stage with rose-colored glasses on the question of who we should trust and not trust. And sometimes, as I say, it's driven by emotional reasons or some non-economic reasons. So I always, pause my clients when they just jump in and say, okay, this is who's going to be the executor. I often will say, well, what are, like you say, what are the attributes you need? And all right, we're going to, you presume you can trust this individual, but, is there going to be tension that gets created? And then does that trust somehow get undermined?
Yeah. So, and maybe we'll get to the impact of that decision on others in a moment. The competence and skill. I mean, people often say, "Oh, I picked this person, but they don't have any business sense, or they don't have any, they're not very organized, or they're not a great communicator." These are sort of the skills. So there's a level of skill that you'd like to see in an executor, and one of them is organization. Financial management is you can buy that. You can buy some of the skills using advisors. When I say buying, hiring people to advise and take care of organization and things like that. But some of those are key skills. The personality is important. Personality, I think, are they going to be able to deal with conflict if there might be? Are they somebody that gets along with people? Are they willing to? Is ego a big issue for them? I'm in charge, and I'll do what you'll do what I say. Those are all impacts on whether that's a proper person. You know what
Yeah,
I
and
mean?
I think ego is the biggest source of tension in litigation over executors, is that the executor is driven by ego, and they are typically wrong when they have an ego. You are in the most vulnerable position at law when you're an executor, and although you have to make tough decisions from time to time, if you lead with ego, you're guaranteed to be in front of a judge.
Yeah, and so personality is very important. The idea of shared values. This is particularly important, funeral and burial, let's just say, because we're not talking necessarily about trustees and making discretionary payments and things like that necessarily, but some of the things overlap for sure. But shared values, if they have no regard for your values as for burial or funeral, well, there might not be the right person to pick as the executor, because they're going to be able to make that decision. Age, health, willingness. Let's just group those three together. This is the ability to do the job and the willingness to do the job. So if you're picking executors who are, in their 70s, and the client is in their 50s, that's probably not a great idea, because they may not be around and able to take on this burden, and their willingness. Now, one thing to say about willingness is, just because they say, "Oh yeah, I'll be your executor," doesn't mean that they have to take that role on when the time comes, right? So something to warn the client about when they say, "Oh, I have to check with John to see if he's willing to be the executor." It's a good idea to check at first instance, but that doesn't mean he's necessarily going to be willing when the time comes. And that's really the hard part. And as Ian said, you're kind of a future teller, or fortune teller, to try to figure out what's going to happen in the future. So that's not easy to do.
Yeah, the next one, impartiality and no conflicts, is always one that you struggle with, because inherent with the job when you appoint an executor 9 out of 10 times is they are riddled with conflict and impartiality. From my perspective, I think it can be a bit misleading when someone says, well, they're going to be in a conflict. Well, I've appointed my wife to be my executor, and if there's a spousal trust, there will be some conflicts. She'll have personal interests and she'll have interests of the capital beneficiaries. But it comes back to that first question you asked, Jordy, is that conflict and impartiality in the context of trust is what I always want to emphasize with my clients.
Yeah, the one that jumps out at me is where you're appointing a business partner as an executor, and there's a bit, you have the client has a partial interest in a business, and they're appointing the business partner to be the executor, who's going to have to be dealing with themselves. So that's the kind of thing that gives me some concern. Residency and citizenship. There's no prohibition against appointing a U.S. person or any person as an executor of an estate. So that's the first thing, because I hear from clients all the time that they've been told that you cannot appoint a U.S. person. You can. There are certain downsides to that we'll talk about as we get further on. But there's no prohibition against citizenship or residency of the executor. So we'll return to that. What about the idea of experience? How important is that, Ian?
Well, the truth is there's very few people out there that would do this job more than once in their lives.
Right.
And so it's funny, it is experience, but it's from the right perspective. It's the sort of things that you're identifying. Is their personality suited for this? Is their ability to stay organized and or hire people when needed to get help as needed? Is their situation, their health and their age and their personal circumstances appropriate? All of that will draw on experience. It's more of a life experience question than the job of executor. We'll talk about appointing third parties and so on, I'm sure, but I always I'm hesitant to talk about someone who's got deep experience of being a private executor, but at the same time, you want to look at the choice of the person and their maybe their professional background and their business background.
So geographic proximity, obviously it's the need to be around is a factor. Let's just talk about relationship impact, because I think this is one that we sometimes gloss over. And by this, I mean, if you're appointing an uncle to be the executor over an estate that's for the benefit of their nieces and nephews, that's going to have an impact. That changes the relationship in some way, or could. They're no longer just an uncle and niece and nephew. They're executor and beneficiary. And that can change a relationship dramatically. In the worst scenario, it can end that relationship. So the idea of, how is that going to play out? And that's really where we as lawyers can add the most benefit for advice, is to say, look, because it's not something that anybody would think of necessarily. And so to play it out for them is important. That idea that it might change the dynamic of that relationship. And the other part of that is, if you're appointing, and we're going to talk about kids and appointing one or more, et cetera, but will that change the relationship in another way by picking somebody or not picking them? So any comments on that, Ian?
No, I agree. I think that's the relationships drive. With great power comes great responsibility, and all of a sudden you're having to make tough decisions, and that's going to impact your social arrangements for sure.
Yeah. So just a few other considerations that might go into this. If you're appointing more than one, obviously, do they get along? And we'll talk about options for more than one executor, but that's a pretty good place to start. Right, Ian? I mean, this is where you would come in, I'm sure.
Yeah, I mean, look, what has happened, I think, over the years is some bad habits have been created, and that is that if someone might say, I want to appoint my accountant and my lawyer and my wife, or and just that people are chosen as a consequence of their role in your life, as opposed to their personality and their abilities to do the job. And this is a classic. I mean, if they don't get along. I've acted far too many times on files where literally two sets of counsel are on for two different executors because they're not getting along so intensely that every decision that's being made is being scrutinized and it's needing legal assistance throughout. So from that standpoint, the relationships of the individual, the personality of the individual, and the ability to get along with the other executor is paramount.
The next three are sort of all tied together, which is, how big a job is this and how difficult a job is this? And it's might be driven by, remember, we're talking executors, not necessarily the trustees, but, business assets that have to be run, complicated, real estate holdings, et cetera. So looking at how big a job this is going to be and how difficult a job is a consideration when you're picking an executor. We're going to talk about compensation down the road, but that's a consideration for clients. Do you have to, does the person have to be paid? And if so, because that is a cost, right? So that's the thing. And then, what happens if that person can't act? We got to talk about alternates.
And I typically don't like my clients leaving the room until they've given me their alternate choice, because it does far too more often than you'd think fall into the hands of the alternate appointment.
Mm-hmm. So let's turn to the issue now that we've been able to get a list of people from potential candidates from the client, and that's sometimes how I would deal with it. When they're not sure. Like I said, look, we don't have to decide this right now. What you want to do, and that's why I'm not a big fan of asking the client in advance, who do you want to appoint as your executor? They don't know, and you don't know until you see the plan and the assets and all of that, who would be a good candidate for that. So that's why I'm not a huge fan of that. I'd prefer to put that at the end, because once you know what the situation is like, that can inform your decision. But once you've got that list of candidates, now we look at kind of two options, right? Either you pick one person to act, a sole executor, or you pick more than one person. So let's just look at this, and Ian, maybe just jump in with any comments you have about the idea of a sole executor.
Well, look, I mean, it's a heavier burden for the individual, but I think the default to saying, well, look, I've got 3 kids, all 3 should be executors, has to be carefully considered in each situation, because sometimes it is just, as for the reasons that you're identifying, it is just the right move to put one person in, and especially when they get along, because it does solve a lot of the logistics. But who knows if they'll continue to get along after death. But I've always sort of, it's a subject, again, like you say, why ask too early? Because you need to understand the nature and extent of the assets and all of that before you want to get into this decision. But a sole executor, there's lots of burden there, but anybody who takes on the job can also get good advisors around them to make sure that they don't trip up.
Yeah, the no one else to blame is sometimes one point I would make out. If they're going to have to make hard decisions, and they're all by themselves, there's no cover there. If there's 2 people, maybe they can share the blame. So then the alternative is more than one, right? And this might be 2, this might be 3. In some cases, could be 8. But I typically say 1, 2, or 3 as options. The burden, the pros and cons are kind of reversed, obviously, from the sole executor. And the difficulty of getting everybody in a room, dealing with financial institutions. The more people you add, the more difficult it is to arrange things. So obviously that, and then the possibility of disagreement, right? So appointing 2 people means that there's no sort of remedy if they can't agree. Maybe, Ian, can you address the whole joint and several appointment, which I have seen wills, and so have you, I'm sure, that say I appoint John and Sue jointly and severally as executors. What's your take on that?
It's got no basis at law. You can't delegate your authority, and it's from my standpoint, it's not even something that we should be considering from a drafting standpoint. I will say though, it used to be until COVID hit. I've learned a lot from COVID, and one of the things I've learned is that it is actually not as cumbersome to run an estate now with multiple executors. Subject, of course, to the banking problems, which we all have our own nightmares of getting through to banks and making things happen there in COVID. But the free flow of information and the ability to do things on Zoom and so online and so on has changed my view that getting in multiple executors. But I come back to the same point that you've made, and that is that I do think it's 1 or 3 Two, it's it often is just going to be in a situation where if you can foresee deadlock, and even if you can't foresee deadlock, you can get into situations where it's unrecoverable.
Yeah, and again, if the will is silent, if you're appointing more than one person, and it just says I appoint A, B, and C, it requires unanimity, and joint and several doesn't work. You should check your precedent to see if you don't use that. If you use eState, you won't see that. I know some of the other software has that as their wording, and it's wrong, and it doesn't really mean what it says, because executors are jointly liable. Banks are going to require both people to sign, and it just generally isn't proper. So, but yeah, then you can build in, if you have more than two, you could build in a majority rule clause and set the rules for that. So, just to keep things moving, we just want to go to some common circumstances. So I just want to deal with, because this is where some of the trouble begins. You've got multiple kids and you say to them, okay, you got options. You could pick one. You can pick, let's say they have three kids. We can pick two. We can pick all three. What's your general, I have my views. What are your views, Ian, on that?
Well, it really does. This is why taking the time to get to know the personalities of who they're choosing and your client is so important, because it really is. There's no hard and fast answer here. As I say, I used to be much more of a fan of just one of three in circumstances like that, because I've always found the logistics being so cumbersome and onerous and delay results from it. I've softened as a consequence of the technology and the abilities to do that, to go to it. As I say, I don't like two. I prefer three if you can. You really do have to balance. I'm right now, you and I are doing one, and we've got three strong-minded men who are in their 50s, all get along, the three boys. My client just feels strongly that it would just offend someone if they weren't in. And in this notwithstanding the fact that one of the children is in the U.S. So, I guess you have to manage your client's expectations, and often they'll ask you for your preference, and it's a tough one now. And I think it's an even tougher question now than it used to be.
My general rule, and though you can disagree with me completely, is that I would default to naming all the kids, unless there's a few techniques here. So even if the idea is that, they'll all want one of them to take, they'd be happy of having one of them appointed. Gives them the option. There's nothing stopping them renouncing and saying, you know what, you take over. I'm happy with my brother doing everything. The advantage of that is it gives them some leverage. So if it's a question of compensation, they can say, look, I'll renounce as long as you don't take compensation, or you take compensation of X dollars or whatever else. If you only appoint one and you have a compensation clause in there, that's might be an issue too. If you don't put a compensation clause and you say they're not entitled to compensation, that's putting a burden on somebody for it just takes away the options that might be available. And so my general rule would be to appoint them. Can that lead to problems? Of course. But at the same time, I think most problems occur when you don't appoint them all. At least if they're all at the table, they have the choice to say, I don't want a seat at the table. And I would encourage my clients, if they're choosing one way or the other, regardless, even if they're appointing all of them or they're appointing one or fewer than all of them, that they try it out and see what the reaction is with their kids. So you say, I was talking to my lawyer, and he said something about just, naming just Johnny as the executor. Oh my, just Johnny? Or, oh, thank God, I don't want that job. Well, that's, and do that individually, just to gauge the reaction. I say to clients, you'll be amazed at what the reaction is. So if the thing is, oh, that's not fair, that's not right, that's et cetera, well, then it's your call as the client. So, and similarly, even if there's a foreign executor, I don't have a problem with naming that person, because they may not be living there at the time of death, and they can renounce if it's too big a hassle. They can always renounce and not take on that job, and unless you get their pre-approval as a parent to exclude them in that decision-making role. I'd be wary of that.
Yeah, I think the other one point, though, of course, is that a U.S. citizen, you've got to be careful that you don't create a U.S. trust. So you want to make sure that the majority are Canadian, for sure.
So there are issues about rendering it. Although my general advice from the U.S. people is that it's not as big an issue as if you're trustees for a trust. An estate where of the deceased who was here in Canada and the assets are in Canada is not as big an issue. There are a bunch of other issues, but and then there's the whole idea about independent executors, whether they be trust companies or lawyers or someone else, friends. Um, my general sense is appointing an independent executor would avoid most disputes that occur in estates because it would give everybody a common enemy, and it would remove some of the power from the siblings. So I am actually in favor of that typically in a higher risk situation where the kids don't get along. Like I would choose that well over appointing one of them or all of them if I know that they don't get along. Ian?
Oh, 100%. And I think people shy away from trust companies too readily, just for that purpose. If you can see the train wreck coming and your client's being honest with you about that, then it is really the best choice. And of course, like you say, lawyers are professionals as well. Uh, but it is hard to watch your family's assets get put in the hands of someone else to be doled out. And so I don't underestimate it, the importance of the decision. And I also know that some people overthink it and some people think it's going to cost more money. Truth is that if you have most situations like this, you're looking at trust companies, you can uh, negotiate the pricing on it. And you can also often in a large estate, a lawyer or an accountant running the estate's cheaper than the 5% in and out would have been anyway.
I always say that trust companies are cheaper than if you hired me. If you hired me, I'm going to seek the most amount of compensation I can get. But trust companies are going to give you a discount and they're going to be around. I may not be around. So there are reasons to do that. I also say, they say, oh, they're going to be expensive. I said, well, they're definitely going to be more than if you have somebody who'll do it for free. But they're not going to be more expensive if you hire, than someone else. So, compensation does fit into it, but and I don't want to cut into your income, Ian, but they're going to, if the kids don't get along, 3 sets of Ian Hulls, not that there's anybody comparable to you, Ian, but if there were, that they're going to burn through that pretty quickly, as well as their family relationship, which I know it's not as important as money, but what we're going to do, because we're right at half an hour and I don't go over, is we're going to defer, we're going to do compensation and do a full half hour on compensation options. So if you came for that and you're like, oh God, this sucks, sorry. But we will do a full half hour on compensation options, planning for it, maybe even talk a little bit about fights over compensation. And because I don't want to give it short shrift because it's an important topic. So I do want to give a promo for next week. Next week, we have a very special edition of eState Academy. We have Dr. Ken Schulman, who is going to be our first ever guest. And he is a testamentary capacity expert, an assessor, physician, professor. And he's going to give us his insight on using contemporaneous assessments and other uses for assessments and ways to talk about capacity with clients. So that's going to be a very special afternoon. So we welcome you all back next Thursday. And I'm going to look to see if there's any questions that aren't compensation based. But I think we've got most of them dealt with. And so thank you all. We like to keep it to a half an hour. We welcome your thoughts and comments, and we'll see you again next week for Dr. Schulman. Thanks, Ian.